Members, this is the appointed time. We have a quorum. Let me call to order the meeting of the Bills Committee of Registration of Titles on Land Miscellaneous Amendment Bill 2025. Let me invite the administration to come in. I'm just reading out from the attendance list. We're joined by Ms. Doris Ho, Permanent Secretary for Development, Ms. Joyce Tam, Land Registrar, Ms. Zhang Hoi-san, Principal Assistant Secretary for Development, Mr. Eric Lee, Deputy Principal Solicitor of Land Registry, Ms. Joyce Wong, Assistant Principal Solicitor, and from the Department of Justice, we have Mr. Chan and Mr. Francois Lam, Mr. Wesley Look, Mr. Anderson Chan, and also Ms. Eunice Wong. So, following from the last meeting, the administration already provided a written response to the views expressed by deputations and individuals at the last meeting dated the 2nd of May, and that's CB bracket 1850/2025 bracket 01. Since members have received this paper in advance, and I'm not going to ask them to go through the paper. Any other views, Ms. Doreen Kong? Well, I remember at the public hearing, the Law Society raised some views, and it is said that a written submission will be provided. Has the Secretariat received that? Right. I think that inquiry has been made for the written submission. I'll invite the clerk to tell us more. Indeed, we inquired with the Law Society of Hong Kong about the written submission and when it will be made. I understand that internally they have to go through certain processes. I know that members are eager to learn about their views, and I'm sure that they will submit the written views as soon as possible once it is ready. Right, since we are moving on to the clause-by-clause scrutiny stage, let's not talk about the practical side of things, because these are matters that the Law Society will look into. Now, I will now move on to the clause-by-clause scrutiny. I think members already discussed the general policy and merits of the bill at the last meeting. We will start the clause-by-clause scrutiny now. The administration will walk us through the bill clause by clause now. Members may wish to refer to the bill and the marked up copy, and for members' convenience, would the administration please read out the page number on the top right corner. Members, if you want to speak, please press the request to speak button. I will now give the floor to Ms. Chair. Right, perhaps I will ask Mr. Lee from the Land Registry to take us through these clauses. Right, we now start the clause-by-clause scrutiny. Amendments to Land Titles Ordinance. It sets out the scope of operation. It sets out, for example, the sections to be repealed, the definitions to be added, and also the scope of application. Clause 3. Certain definitions will be repealed. I will divide the amendments into 5 categories. The first category is added definitions to new land, including the definition of the new land. You will find the definition on pages 12 and 13 of the marked up copy. We also have the principal lease and the sublease and that's page 11 of the marked up copy, and also short-term lease on pages 12 and 13 of the marked up copy. We also have a revised definition for new land, and means land held under a government lease granted on or after the commencement date for a term commencing on or after that date, but does not include land held under a short-term. Sorry to interject. Can you start with 001 and go through each and every page? That means every definition. We need to check the definitions. Well, I want to go through the amendments in general, but never mind. Let's do that. Let's follow the chairman's suggestion. Let's go through the clauses page by page. Right, for the benefit of members, we're trying to catch up. Mr. Lee tried to give an overview to members about the amendments that will be made to certain definitions in the interpretation clause. But if members would like to go through each and every clause, then let's do that. Page 1. The definition of the term land will be amended. There is just an improvement on drafting aspect, no change to the substantial meaning. We're also going to repeal the reference to the definition of the existing of land, so there is no need to refer to the old definition. Any questions from the Deputy Chair? 121. Unless otherwise referred to. Now, I was in the other room scrutinizing another piece of legislation, and there was something similar. And then I asked this question, unless otherwise referred to. Now, that is not the phrase to be deleted. So can you explain why for this bill, this expression will be deleted, but not the other one? Now, we've looked at the provision specifically, and we believe that this expression should be kept. Perhaps I can give the floor to the DOJ now. Please switch on the mic. Thank you, Chair. Thank you, Member, for the question. Cap 585, Land Titles Ordinance, provides that we need to consider the context if the definition is not found in the interpretation clause. So if the term is not to be defined by the interpretation clause, then we should consider the contextual meaning. Cap 585, 128, and 430A will be amended by this bill. The concept of registration of titles and land is applied to various provisions, and that is why we propose to keep it here for the benefit of readers. We believe that it is appropriate to keep this expression, and that is why we have decided not to delete the original provision in Cap 585. So in other words, unless the context otherwise requires is not to be deleted. Right. About the definition of land. For Fairview Park and the other estate in Tai Po Hong Lok Yuen, they don't go by the undivided shares. Well, this is an inquiry I've recently heard from residents. For Fairview Park, for example, the titles are divided not by undivided shares but by different lots, because these are standalone houses. So will the new definition of land cover the properties I mentioned? That is Hong Lok Yun and also Fairview Park. Land includes land as well as undivided shares, be it a division by lots or by undivided shares. They will be captured by this definition. However, there's something else that will be affected. The DMCs of buildings will also be included under this definition. Mr. Tony Che. I have a question for the administration. Because the land boundary map will be repealed. That land boundary plan, is it because the boundaries will be clearly demarcated that you don't need a definition here? And I also like to go back to the preamble, because the preamble provides the short title as well as the commencement date. And it is said here that the ordinance comes into operation on a date to be appointed by the Secretary for Development by notice published in the Gazette. I remember the same appeared in 2004, and yet the LTO has yet to come into operation. So what should be done? Will both ordinances come into operation by appointment of a date at the same time? Well, I think last time the Secretary already explained the point about land boundary plan. The land boundary issue should be dealt with separate from the title registration exercise. I think the Secretary already gave an answer last time. Well, I'm talking about this definition being repealed. Right, I'll just let him finish his answer, and then Mr. Tony Jack can ask a follow-up question. Back to commencement. The commencement date will be published by notice in the Gazette. As for the LTO passed, or land titles bill passed in 2004, the ordinance has yet to come into effect. So in other words, as I understand, the land boundary issue will be dealt with outside the bill, not within scope. Please continue, Mr. Chair. I think he's just reading out the bill, but he didn't explain the reason, because here the definition for land boundary plan will be repealed. Can you explain the rationale why you delete this definition? Is it because there is no need to keep the definition from now on? Don't just tell me that it will be repealed and dealt with somewhere else. The next point is about the commencement date. We're talking about two different pieces of legislation. This one is the Registration of Titles and Land Miscellaneous Amendments Ordinance. So this is to come into operation on a date to be appointed by the Secretary. We don't know when this will come into operation. I want to know the correlation with the commencement of the land titles ordinance. That ordinance has yet to come into effect either. I just want to know, in terms of both pieces coming into operation, are there any correlations? Right, two questions. First, about this definition being repealed and the correlations of these two enactments. I'll try to answer these questions. First, on question 1, we propose to repeal the definition of land boundary plan because at present the land boundary plan was added to the last bill, amendment bill to the land titles ordinance. Well, as per the last proposal, we considered along the lines of land boundary in order to resolve certain issues. But like I explained at the last meeting, we don't find it appropriate to handle the issue of land boundary through this amendment bill, and that is why we've decided to repeal this definition altogether. Like Mr. Lee said, in fact, at the last meeting when we received deputations, and as mentioned by the Secretary for Development, there would be another opportunity for us to rationalize matters relating to the land boundaries, and we'd like to make use of another opportunity to consult the sector about that. So it was at the last exercise that we considered resolving the matter of land boundary through that amendment bill, but we decided not to go ahead with the same thought this time, and that is why this definition be repealed. The next point is about the commencement date. As Mr. Lee just now explained, that bill was passed in 2004, but it didn't come into operation. Now, supposedly, a notice had to be published in the Gazette for that bill to come into operation. So that ordinance has yet to commence operation. Now, as we go through these clauses, I'm sure that members will have a better picture. The idea of this amendment bill is to give effect to that bill passed in 2004, including the issue of land boundary plan, the definition of which will be repealed. Now, once we have completed the clause-by-clause scrutiny, when the second reading of the bill is resumed, then according to the preliminary section of the bill, the Secretary will publish a notice in the Gazette so as to tell everybody when this miscellaneous amendment bill will come into operation. As explained before, we plan to have the bill come into operation in the first half of 2027. Before that, we will have to make subsidiary legislation as well.
Well, I think it's quite clear, Mr. Tony Te. In relation to land boundaries, we emphasize new land. When it comes to the land boundary of new land, it needs to be signed by a registered surveyor. So you need to explain the fact that you delete the interpretation of the term land boundary plan doesn't mean that it's not important anymore. It's still important. The boundary of land is very important. Otherwise, it makes no sense to mention or to describe the land. We have coordinates about land. That's why it is important. We need to explain clearly the fact that the boundary of land is important. I haven't yet gone through the entire bill. We need to emphasize land boundaries are important. That is on the one hand. On the other hand, in relation to the LTO, which was passed in 2004, it hasn't yet come into operation. Just now you explained this is a miscellaneous amendments bill. This miscellaneous amendments bill doesn't have anything to do with the LTO, that is the principal legislation, in my opinion. The principal legislation hasn't yet come into operation. Now we are proceeding with the easiest part first. The miscellaneous amendment bills doesn't have anything to do with the principal legislation. So even if the former hasn't yet come into operation, the miscellaneous amendment bill can still come into operation. Is that right? Well, land boundaries are important. As I explained at previous meetings, for newly granted land, the Land Department has land surveyors. They need to survey the land boundaries before they grant the land. So these surveyors have already dealt with any issues in relation to land boundaries. I understand Mr. Tony Tse's question on the commencement date. This bill covers miscellaneous amendments. To a large extent, this miscellaneous amendments bill amends the Lands Title Ordinance Cap 585. It was passed in 2004. So the LTO Land Titles Ordinance will be amended by this miscellaneous amendments bill. So Cap 585, which has already been passed, will be amended by this miscellaneous amendments bill. So Cap 585 is amended by miscellaneous amendments bill 2025. That is the bill we are scrutinizing. Thank you. Next member, Mr. Louis Long. Thank you, Chairman. I'd like to write on Mr. Tony Tse's point. Land boundaries are very important to us. Now, you propose to delete the definition of land boundary plan. Like Mr. Tony Tse, I haven't yet gone through this very thick pile of documents. Does it mean in this round of legislative amendments there is nothing about land boundary plans at all? Is that the reason why you propose to delete the term land boundary plan under interpretation? Thank you. Which official will take this question? Well, I will try to take this question. Thank you, Chairman. In relation to amendment proposals, in the LTO, which has been passed, there is a mechanism for determining the boundaries of different lots of land. Land boundary plan is covered in the said mechanism. About 2 decades ago, there was much discussion on this. Back then, the Legislative Council agreed to handle land boundary plans separately. That's why we propose to remove land titles to remove land boundary plan under the Land Titles Ordinance. In Section 94, it will be removed. That's why land boundary plan will no longer be mentioned. That is why we no longer need a definition of this term. All right, Mr. Louis Long, I accept that you propose to remove it. But it doesn't mean the fact that you delete it means the issue about lot boundaries has already been resolved. As the Permanent Secretary said, by way of other means, I'm not sure whether you need to do so by way of administrative procedures or legislative amendments, how you're going to do it. But I think this is very important. I propose to add a footnote here. Thank you. Moving to page 2 of the marked up copy. That is the Chinese marked up copy. The unregistered interest definition is no longer needed. Then on to page 4, the definition of the word instrument. In document, we propose to remove in addition to a document in writing. Next, page 4, instrument. And then about another amendment, is an amendment in the wording of one of the terms. Mr. Eng Kong, we have an interpretation of instrument, and we also have an interpretation for document. Well, I do understand the changes in instrument, but I'd like to know why you set these terms apart, that is instrument and document. Is there any overlapping? Yes, there is overlapping, but then the document has a wider definition. Apart, well, in addition to instrument, document also covers map, plans, drawings, disc, tape, film, tape, and so on. In other words, the interpretation of the term document is wider. Alright, let's continue. Page 1, we propose to remove the application interpretation, and we also propose to remove the interpretation for transaction. Then we move on to lot number. It's on page 7 of the English marked up copy. It is an enhanced version of the previous interpretation of lot number. Another definition is also proposed to be removed. That is the interpretation of remove. Present inhibition chargee lessee. We also propose to remove these interpretations. Lessee, that is in relation to a registered long-term lease. We propose to change it to in relation to a charge or statutory charge, means the owner of the charge or statutory charge. Lessee, we propose to add paragraph B in relation to any undivided share in registered land held under a registered long-term lease, the owner or holder averts to the like effect on the undivided share. Hang on. Mr. Incong, Deputy Chair. Thank you, Chairman. I'd like to ask about the term lessee. Does the definition of lessee cover the housing estates in which one doesn't have interest, only subsection? Well, I believe we add the interpretation of lessee for the sake of a registered long-term lease. We use the term lessee to refer to the owner of a registered long-term lease. Thank you. Please move on. All right. Charge. That is page 1 of the English marked up copy. We have added some contents to the interpretation of charge. There are textual amendments in addition to the amendments made to the definition charge. Mr. Tony Tse. Thank you, Chairman. Charge, brackets B, does not include a statutory charge or a charging order. In relation to chargee, in relation to a charge or statutory charge means the owner of the charge or statutory charge. May the administration explain the differences between these two?
Yes, please explain. I see that this is a big change I think that members would like to know why. A charge is what we usually call a mortgage. That means you mortgage your property to the bank. The bank can proceed directly to the mortgagee's sale or foreclosure. A statutory charge or a charging order is different from a mortgage in the sense that the holder cannot proceed directly to foreclosure or mortgagee's sale. In order to execute this charging order, the chargee must first apply to the court for an order of sale first. So by using this term charge nowadays, it's akin to the concept of a mortgage. Is that clear, Mr. Chair? Let me mull it over. Please continue. Next, charging order. This will be amended. It means an order of any court, and then for securing the payment of a money due or to become due under a judgment of order of the court. These expressions will be repealed because we believe that there is no need to honor and judgment before payment is to be made. Now back to the question on the charge. What if I use an indemnity clause instead of a charge? Is it similar to a charge? Indemnity clause is an undertaking or is a contract. It does not impose a charge on the property. But what if I include property as a collateral in the indemnity arrangement? Is it something similar then? Yes, if this is, if the property is involved. But it's not included in the charge here. Right, that depends on the purpose of including an indemnity clause in the instrument. Do you want to pledge the property to the creditor, or is it just a simple indemnity? That depends on the purpose of including the indemnity clause in the instrument in deciding whether it's just a charge or is it just a mortgage or a claim, like NCC, that non-consent caution, something like that. Right, three members have follow-up questions. Mr. Tony Chair, would you like to ask your question now or later? I see your name appearing here. Mr. Louis Long. Chairman, the same question on charge. I'm reading from this English version of the marked up copy. And I see A and B under charge. A means a charge does not include a statutory charge or charging order. That's under B. For charging order, the definition is now improved. I haven't finished reading, but apart from a definition for charging order, is there a definition for statutory charge in this bill? Mr. Lee. The answer is yes. There is one for statutory charge. So where is it? I think we will come to that eventually, but do tell us where it appears. Right. I'll give you some time to check, Ms. Doreen Kong. Chairman, let me help. You asked a very good question about indemnity and guarantee, whether it constitutes a charge. Now, charge means a legal charge as defined by Section 2 of Cap 219, as it says here. And then A, Roman numeral 2, a mortgage. I stand to be corrected, Mr. Lee, but to me, a legal charge must be expressed to be so. It's not just a guarantee. It must be signed by the property owner. It comes in a certain form, like a deed. So an ordinary guarantee involving a property is not a charge. You need to expressly provide that this is a charge. Right, please continue, Mr. Lee. We're on page 6 of Chinese version of the marked up copy. Trustee. The definition has changed. Originally includes a personal representative, and now, to avoid doubt, it does not include a trustee in bankruptcy. Because there will be a new definition for trustee in bankruptcy. Entry or matter will also be deleted. Please wait, Mr. Ambrose Lamb. Having heard Mr. Tony Chair's first question and the Permanent Secretary's reply, I don't think we need to go through the old definitions. We can just move on to the new ones, but it's not as simple as that, because if we take a look at the old ones, for trustee, I see that it includes a personal representative. Then, of course, apparently, it's easy to understand. Now, under the new definition, it does not include a trustee in bankruptcy. Well, but that's really wide in scope, because I may have trust and I may need to engage a trustee. So what about trustee of a trust? In the case of bankruptcy, then clearly this trustee, the situation is quite apparent. We have separate definitions for trustee in general and trustee in bankruptcy, so that there is no duplication. What about other situations where a trustee may come in? Say we have a trust document, and you're one of the trustees of that trust document, then are you included? The answer is yes. Then I think it's quite ambiguous. Are you going to provide an exhaustive list? Well, I think that we provide here includes a personal representative, and then to avoid doubt does not include so and so. I think it's clear enough, because as I understand, there are different types of trustees, including an agent and other scenarios. So that means if it's not expressly provided here, then it should be included. So the only exclusion is a trustee in bankruptcy. Any other questions? My question is, it's really difficult to find out here whether trustee in other circumstances is included. So that means there is only one exception here. Other kinds of trustees are all included. Right, then now I get it. Only the trustee in bankruptcy is excluded. Otherwise, all other kinds of trustees are included. P.S. Any response? Well, I think Mr. Lam has a point. We'll go back and give it a thought. Long-term lease, the definition will be amended. Apart from paying a premium, we've also clarified the tenor, and that's the tenure should be considered at the time when the application for registration of the lease is lodged. Ms. Doreen Kong. Well, I think there is a substantial change in the definition of long-term lease. I'd like the administration to show us and give us some examples about what a long-term lease is. It seems different from the original definition. I see that the original definition, point B, not at rent, has been deleted. Can you give us examples for illustration, Mr. Lee? The concept of a long-term lease refers to your being akin to an ownership and not just a tenant. For example, you may rent a property for 3 years, but you don't consider yourself an owner, but rather just a tenant. It's still short term. So what is called a long-term lease, we've laid down some criteria. For example, is a term of not less than 21 years, and you're not paying rent. We don't use this concept. Instead, you secure this long-term lease through paying a premium. By paying the premium and having the lease of this period of time, you are akin to owner of the property. I can give you one example. Robinson Place is one such example. There is a government lease granted, and that this company works with a developer, and that's Swire, not Carey. And then this Robinson Place development is completed. It's not, and for the interest sold, it refers to interest under this lease, not under the government lease. So for this, we want to capture this kind of property arrangements in the bill. I think as far as the concept is concerned, you can call it, you can call yourself an owner rather than a tenant if you're covered by a long-term lease. Dr. Wendy Hong. For some schools, religious premises, and also other sites, they may have long-term leases of more than 21 years. Would the tenants be considered de facto owners as well, Mr. Lee? As I understand, the examples you mentioned are not long-term leases because these leases are granted by the government to some organizations. So these are just ordinary government leases. So you need to go through the criteria A1, 2, 3, and only when all three criteria are met can it be called a long-term lease. That's the definition, but you mentioned the leases to organizations, and this is not covered because it's kind of a government lease. Deputy Chair, Ms. Doreen Kong. Excellent. So I'm reading from here the definition of long-term lease. It does not exclude a government lease. I understand your explanation given to Dr. Wendy Hong. But just by reading this text, a long-term lease could mean a government lease as well. Long-term lease itself does not include government lease. Mr. Andrew Lam. Thank you for explaining to us what a long-term lease means. One example is the Robinson Place. There are also other examples in which a 999-year grant is given, but to some extent there is still a high degree of control. As I understand from the text here, the only criterion is the period of time and not the extent of control. In fact, Leighton Hill provides one of these examples. For some lots, you have the whole lease being let. I don't want to cause more controversies. I'm just talking about what is released in the public domain.
Okay.
Yes, for the definition of long-term lease, we only look at the duration or the term of the lease, that is whether it is not less than 21 years. In relation to the control or management, these are set out in the provisions of the lease. The owners are subject to such provisions, and we will come to this when we talk about the effect. As for Dr. Wendy Hong's question, it's about tenancy. It may be clear in the English text, whereas in the Chinese text, it may be quite ambiguous. That is tenancy and lease. Probably you need to give it some thought in order not to cause any ambiguity. Thank you. Dr. Wendy Hong. When it comes to lease, is it a private treaty grant? Do you consider it a government lease? Well, if it is granted by the government, then it is a government lease. Let's continue. All right, we have come to another definition. That is date of first registration. We refer the reader to section 22 and section 49 brackets 4. We also propose to delete another definition. That is appointed date restriction. For the definition of record, we have made improvement to the text. We also set out more clearly what it covers and means. Hang on, Mr. Ambrose Lam. Solicitor, you keep it. That is in relation to Cap 159. Solicitors and barristers. We're clear about the differences between these two practitioners. However, in some ordinances, it's quite ambiguous. Lawyers cover solicitors as well. So I need to make it clear. Solicitor here refers to solicitor only. It doesn't cover barrister at law. Is that correct? Right, that is correct. Thank you. Entry. We have also revised it. We have made enhancement to the meaning of the term entry. Mr. Eng Kong, I can see entry in relation to the title register includes a note and notice in the title register. However, there is no definition of note and notice. They may have a wide meaning, so I'd like to know what kind of notice and note would appear in the lease. Mr. Lee? For what will appear in the title register, it is actually within our control. We won't put anything not related in the register. We only put what is relevant in the register. For example, we have a restriction order. That is, the director may impose a restriction order in relation to the disposal of a property. This will be written in the register by way of a note or a notice. Director, well, I can give you an example. Say the certificate of title. We set out the serial number of the certificate of title. For replacement, that is for a reissued certificate, we set out clearly that it is a replacement. It may not be an entry, but we do need to provide supplementary information. So the person reading the record will have a full picture of the situation. Mr. Kong, land register is quite abstract. We, or I at least, haven't yet seen the register itself. I understand we haven't yet confirmed it, but can you give us an idea? Well, that is what a register will look like. Can you show us what it will look like? That will give members as well as the industry peace of mind. I cannot visualize a title register. Yes, we have actually prepared it, but we haven't yet come to that part. Well, you can talk about it when you have come to that part. Thank you. Next, Mr. Tony Tse. Yes, we see the amendment to the term entry. What is the reason behind the change in the definition of the term entry? We've enhanced the contents of the definition of entry. We manage the register and we decide what can be put in the title register. Well, we may show you samples of the title register in a moment. You may see that it is very similar to the existing register. That is the land register. Mr. Tony Tse. Well, you don't include other entries. So for note and notice, you will keep these words, note and notice. Well, entry includes other entries. This remark seems to be circular per se. It seems to be circular in nature. I mean, you don't have to further explain entry. DOJ, thank you. The definition of entry includes the word means. It means an exhaustive list. However, in our amendment, we use the word includes instead of the word means. That is, we understand the word entry from an ordinary sense. So in addition to any ordinary understanding of the word entry, entry also includes a note and notice. I hope I can answer Mr. Tony Cha's question. Well, it already covers note and notice. Okay, let's move on to the next definition, disposition. There are textual amendments. Mr. Andrew Lam. Mr. Andrew Lam said that he would say something about the term disposition. We can see brackets A and B before the amendment. We can see an agreement to transfer, an agreement to charge. By asset, by stocks, by bonds. These are common interest. If I just look at brackets A, 1 and 2, these are acts. They aren't included. In brackets B, does not include an agreement to do such an act. Are they really agreements? They are provisions within an agreement. If someone fails to meet a requirement or does any act, then the other person may exercise his or her interest or right in accordance with the provision of the contract or the agreement. So I need to understand brackets A and brackets B. I need to know what they refer to. Usually when I don't understand the Chinese text, I go to the English text and then I will understand what it means. But this time around, when I read the English text, I'm none the wiser. So I want to know what it really covers. Mr. Lee. Disposition means an owner of the property does something to transfer the interest to the other person. Say an agreement to transfer, an agreement to charge, or an agreement to grant lease. All these are examples of disposition. In your example, when it comes to an agreement, the agreement per se is not a disposition. It's a consent, caution to protect the person receiving the interest as a result of the agreement. Ms. Andrew Lam. So agreement is not included. We need to remove it, right? I'm not saying that I agree or disagree. I'm just focusing on the interpretation. Regarding charge, there is a clear definition. Consent, caution, together with the other two, they cover all. That is, one need to register in relation to the interest. When one has disposed of the interest, then the disposition can be registered. If it is simply an agreement, then one needs to use a consent caution to register the interest.
So that's what I mean. Charge, disposition, and there is no need to register the disposition together with consent caution. These three should cover all matters that must be registered. Disposition, transmission, and consent caution. They should, the three things should be as I mentioned. Deputy Chair. Right, what about short-term tenancies that may, or provisional lease that may go beyond 3 years? Would it be regarded as disposition? Yes, please go on. The definition of liquidator will also be repealed. It's no longer necessary to keep it here. Likewise, for register, we've made some textual changes. Page 9. Registered land. We've deleted Schedule 1. The reference to Schedule 1. Schedule 1 Section 2 specifically, because this section refers to conversion, and this no longer applies here. And then registered matter, again, this will be repealed. It's no longer necessary to keep it here. Registered long-term lease. We make a reference to Section 49, and we've deleted the reference to Schedule 1. Memorial, not necessary to keep it here. It's under the current LTO. This word current, we no longer need to give it a specific definition. We go by its general meaning. Transmission. We've improved this provision to clarify our position. Page 10. We've deleted the phrase image record, and we have improved the imaging methods definition. Owner. Likewise, we've improved drafting and clarified the matter. Owner means owner of divided share and owner of a long-term lease. Personal representative. Again, we've improved this definition. Page 11. Transfer. It means the passing of the title to a registered interest or charge from one person to another, otherwise than by transmission. Yes, please continue. Page 15. Sorry, we need to go through the new definitions in pages 11 to 14. They include the principal lease. Mr. Andrew Lam, do you want to answer a question about transmission? Right, I have some questions about pages 11 to 14. No, not on page 15. I want to ask a question about new land. Right, please go through pages 11 to 14 in detail. Yes. We have some new definitions in pages 11 to 14: principal lease, commencement date, inhibition order, statutory charge, etc. Any particular questions you want to ask? My question is on new land. New land means land newly granted or surrendering of the grants. Now, we just refer to some examples, such as Robinson Place. Basically, it's land carved out. It's a lot carved out from the original lot, and in theory, a new grant should be given. Well, perhaps I will let you answer the question. I am not going to make any assumptions. The second scenario is this: as I said, part of the lot is carved out, the tenant remains unchanged, but the original owner retains interest over that parcel. Just like the Shackle example, the owner has a voting right. So about the specific operation here, I need to give you this example to make sure I know what is included and what is not. New land means land granted under a government lease but not long-term leases. And the definition provides that land is granted under a government lease on or after the commencement date, or for a term commencing on or after that date. So in other words, the Robinson Place example does not apply, right? Because according to the existing lease of Robinson Place, it's a government lease, is not a new land, right? Just to clarify, even if this lot is carved out, it's not a surrendering of the grant, it's not new land, because we have some additional owners. Now, the Robinson Place enjoys a 999-year government lease. Even if the subleases are granted after the completion of the development, they would not be regarded as new land. They still come under the original government grant. Ms. Doreen Kong. Let me turn to the definition of new land, B3. Land being the additional land. I know that there are lots of exclusions under new land. B3 is one of the exclusions, that is land being the additional land. There doesn't seem to be a definition for additional land. No, if my memory serves me right, please go to the capital letter B here. There is a definition. Right, Chairman. So I'm imagining a scenario in which we have a big piece of land being additional land. It is possible, right? According to the definition here, additional land is not covered by the definition of new land. Is it your policy intent that additional land be included? Because it says regardless of the size here. So my first question is whether it's indeed your policy intent. Second, new land does not cover short-term leases or short-term tenancies. In the future, there may be dealings with operators of short-term tenancies. So how should we go about that? Should we conduct land search on the basis of that being an old land? say if I am to have any dealing with a member of the public on a short-term tenancy, what should I check? Mr. Lee, the first question is on additional land. Indeed, regardless of the size, this applies. Because this land is in addition to the land covered by the existing lease, and the ownership is decided according to the existing ordinance. There is no way for us to verify titles. So additional land should come under the existing system, and that registration should take place on this basis. The second question is about short-term tenancies. Is that right? Deputy Chair, are you referring to STTs granted by the government? Under the current system, there is no registration. I suppose you're referring to short-term tenancy sites operating as car parks. No registration. Right, excellent. Let's say if I am involved in some short-term tenancies under the new registration system, and there is no proof I can offer. Say if I am to take out a loan, there is no proof that I operate on a short-term tenancy. Is that right? As I understand, for short-term tenancies, the owner cannot sell it, cannot use it for any other purpose other than the specified ones, such as a car park. Right, but let's say if I want to take out a loan, I need to show proof that I operate at this this business on a short-term tenancy. I don't seem to have any memory of it. Can you check? There is no registration. I think that on the Lands Department's website you will find a list of short-term tenancies. But it may not be exhaustive. In the end of the day, you may need to make an inquiry with the government. P.S. Anything to add? I think Chairman's right. The Lands Department maintains a website. The Geo-info map page provides information about all short-term tenancy sites. But Chairman, you just referred to the list being non-exhaustive. I don't think that's true. I believe it is an exhaustive list. I'm not sure whether Chairman refers to the records not being updated, but in theory, the Geo-info map maintained by the Government Department includes all short-term tenancy sites operating under government leases. The majority of these tenancies run for less than 7 years. We have an intact record. Chairman, I came across some STT sites in the past. In my recollection, some of these sites are put on the register, but I'm not sure whether it's true. My question is, from where can I find information about the STTs in the future? Now, I want to explain, it's not just about taking out of a loan. It's about the right of an individual in, say, transferring this business to somebody else. And if I am the buyer of the business, I need to verify whether this seller does have the land interest he claims. So I want to know the reference that I could make in the future.
New definitions. Lodge on page 12 of the English markup copy. Mr. Tongniche. Thank you, Chairman. For these definitions, for instance, we cover short-term tenancy, less than 7 years, and we also saw long-term lease, not less than 21 years. What about those exceeding 7 years but less than 21 years? Is there any definition for a lease of this tenancy? A tenancy may not be 7 years. Is there any will you incorporate any flexibility? It seems there's no middle ground. What about those between 7 years and 21 years? Is there any definition for lease of this tenancy? For short-term tenancy, their lease is granted by the government, but then we don't include it in the definition of new land. As for STT, there is no lot number, as I understand. As for long-term leases, they aren't granted by the government. They are granted by the owner by way of a sublease. There is no overlapping. They are granted by different individuals. It's about a form of property ownership by way of sublease. For a lease with a tenancy of longer than 7 years, it won't be dealt with, right? P.S. Well, I will try to take this question. As Mr. Tongniche said, some government land granted by the government for use as a dockyard, probably 7 years, are too short. So we may consider granting land with a tenancy of no less than 7 years. In other words, longer than STT. In new land, brackets B, brackets 1, new land doesn't include land held under a short-term tenancy, STT. I'm not sure whether this would still be called STT, but then for a land held under such a tenancy, it won't be included under the definition of new land. Alright, moving on to the next, page 14 of the English marked up copy standard terms document. We will come to that later on. Next, cautioner, page 11 of the English marked up copy. It refers to the person lodging an application. Page 15 of the marked up copy, some textual amendments. Hang on, Mr. Rincon, Deputy Chair, would like to speak. Thank you, Chairman. Well, I'm reading the English version. I missed something. I'd like to talk about registered interest. We can see brackets ABC. Bracket C, any undivided share in registered land held under a registered long-term lease. For Robinson Place, for a unit in Robinson Place is included or is covered in bracket C, is that right? Yes. Thank you. Page 15, amending Section 2 is a textual amendment. The entering of the name of a person in the title register as, and then on to page 16, application Section 3. We amend Section 3, brackets 1. This ordinance applies to new land. Hang on, Dr. Wendy Hong. Page 15, the name of a person. The person being the Well, I mean, is it just the name of that person, any other personal particulars? We will we'll refer to a sample of a title register. It will be clearer when we refer to a sample. It sets out the format. That is specifying a person as being the owner. Page 16, subsection 1, this ordinance applies to new land. We just made it clear. Page 17 is a textual amendment as well. It's a new definition, cap 117. It already represents the ordinance. It's about part 1. Any questions? No. You can move on to part 2. Well, excuse me, Chairman, we have an amendment in part 1. We propose to move an amendment in relation to court with a capital letter C. We meant the court of first instance. We have taken into account the view of the judiciary. We propose to amend the definition of court so that it means the court of first instance and the district court as well. Any question? Just now, Mr. Eric Lee refers to court with a capital letter C. Well, it should be court with a capital letter C. That is page 5 of the Chinese markup copy and page 2 of the English markup copy. There are capital letters in the English version, but then there is no capitalization in the Chinese text. So in the Chinese text, we use 2 Chinese terms, whereas in the English version, we use capital letter C and small letter c to represent 2 different terms. Thank you. Please continue. Alright, I'll now move on to part 2.
Sorry，見到你又嚟。我哋第二部
In part 2, we have prepared some PowerPoint slides for members. Thank you. Sample of a title register. Section 4. This sample individual title register is quite similar to the title register, the land register. We can see the particulars of the relevant land. That is the lot number, lease term, commencement date, and so on. We can also see information about undivided shares in land, address or location. These are similar to the information in land register. Mr. Enkong, well, can it be not so similar to the land register? This is indefeasible. For an ordinary individual holding these two different documents, one cannot tell the difference between these two documents, one being new, one being old. Mr. Eric Lee, yes, this is indeed a very good suggestion. We are considering putting a watermark or a large letter T for people to tell the differences between these two documents. Well, we are still planning the design of the document. They will look different, Mr. Ambrose Lam. Do we only have the English version of the title register? Do we have a Chinese version? Well, it should look the same as the one you are looking at. We have both Chinese and English. Will you have Chinese and English, two different versions? Well, we have Chinese information on the sample, as you can see. Many mainland people come to Hong Kong to buy property. The title register is actually similar to the land register. Well, time has changed. Mr. Ambrose Lam is suggesting that you add more information to the document. Mr. Eric Lee, well, it depends on whether the instrument contains such information or not. Next page, we can see the information of the name of owner. It is similar to the land register. We can see the name of the owner, the capacity for tenancy in common, the lots or the shares will be set out in the document. Will you provide this document to us? Well, we have already sent it to members. Dr. Wendy Hong. When someone uses this document in a property transaction, it shows that I have an indefeasible title, but who is there to verify? Is that a lawyer? A lawyer needs to verify the identity of the individual, say checking the ID card and the certificate of titles. In the deputation hearing, we already said that a lawyer would be responsible for doing so. Well, is there anyone responsible for verifying the identity of the person? A lawyer is responsible for verifying the identity of the person concerned. Mr. Kong, is that encumbrance? Yes, we still call it an encumbrance. Is similar to the existing land register. We can see pending application. Mr. Kong.
Right, it's a question from Mr. Lee. I'm sorry I haven't finished reading. Perhaps the answer will appear somewhere later. But here, where do I find this word encumbrance or encumbrances? The bill does not specifically refer to encumbrances? Well, that's exactly my question, because under this new system, if I have the certificate of title, then I have the trump card. The certificate trumps everything. So unless encumbrances appear somewhere in the bill, we should do away with this term altogether, because as far as the law is concerned, encumbrances would affect good title. So if we are to introduce this new system, we shouldn't even use the term encumbrances. Mr. Lee, would you like to supplement? Anyone from the DOJ? Thank you, Chairman. We can turn to Clause 37 for a reference to encumbrances. Well, this exists in the original ordinance, and this will be kept in the bill following the design of the ordinance. Right, we'll come to that when we reach 37. Mr. Lee, please continue. Next, application for registration, or the applications register. This is similar to the memorial date book in the existing LTO. It sets out in chronological order the applications received on a daily basis. Applications for registration, in other words. The register sets out the application number, nature of application, nature of supporting instrument, address, location, as well as the lodging party. Applications will be put on the applications register whether or not the applications are successful. All right, Mr. Andrew Lam. Point of clarification, because you mentioned twice petition. I would just want to clarify that the application is to be lodged, not petition. Please go on. Let me now turn to part 2. Clause 5, amending Section 4, and that's pages 18 to 20 of the marked up copy. It sets out details to be included in the title register, including interests, held by tenants in common and their respective shares, as you can see in the sample. It also clarifies information relating to pending applications and the relevant supporting instruments. They don't form part of the title register. And then subsection 4, it sets out the title register as conclusive evidence. So that's a mirroring of Section 4, subsection 4 of the current LTO. There are also other drafting amendments without substantial changes to the meaning. Ms. Doreen Kong. Page 19. C. Let's go to C. The name of the charger. is it that the name of the borrower will not be put on the register? That's correct. We have no plan to do so. The charger is the owner. What is the arrangement at the moment? Is the name of the borrower put on the register as well? No. Mr. Andrew Lam. Page 18. In fact, starting from this page, I see the expression known to the registrar. It appears a number of times. On what basis does the registrar have knowledge of these matters? Is it on what is set out in page 20, 4(b), any other matters shown in the title registrar? Or shown in the title register? Or is there other consideration? Let's say for 2A Roman numeral 8, it says if the lease is held by more than one lessee as tenants in common or as a trustee or otherwise, how is it known to the registrar? We require this information to be provided on the application form. So the information is to be taken at face value as per the application form, or should there be supporting instruments? There will be supporting documents for the application forms. We will verify the documents. The information will be further verified by a solicitor. So my understanding is that according to 4(2)d, the requirements should be met, or should I put it that way? The instruments mentioned are all covered here, right? Instruments that support the registration of the matter. Mr. Rincon, I hope the land registry will go back and check the following. In my recollection, if there is a so-called third-party charge, the name of the borrower should be included in the remark under the current arrangement. Please go back and check, because here in the proposed system, the name of the borrower will not be included. The other matter is about the subject matter of the charge. Sometimes only part of the property would be put on a charge. In the past, there will be a reference to this arrangement. It will appear as PT to the assignment or mortgage. Mr. Lee, well, say if you mortgage 3 properties, then in the register you may find this bracket PT expression, which means that this mortgage affects not only this single property but other properties as well. What about the new system? Will there be a similar reference? It is important. Or we can give it a thought. But from the perspective of a title register, whether or not we include the expression PT, the property will be affected by the charge. Right, Chairman? But as per the current system, if we know about this partial mortgage, we may have other thinking. It is important to those who will be dealing with the property. I want to know whether the same reference will be included in the proposed system, or is it a change in your approach? All right, understood. We'll go back and check whether the existing practice is as you put it, and we'll consider whether to put a similar remark of PT. Right, I want to ask a question as well. In terms of land or titles, there may be divided shares such as 5%, 3%. but it doesn't spell out exactly which part. It only refers to the portion of shares you have. Say, if this property is mortgaged, then perhaps only somebody having a certain percentage of the shares of the title have mortgaged the property. Will there be any indication? I think we'll take a similar approach. There will be a remark we will put down this identity of the owner and the respective shares in bracket. Right, if there are no further questions, please go on. Clause 6 provides new sections 5 to 7. You will find the provisions in pages 21, 22. Section 5, Applications Register. It is an improvement to the existing applications register in Section 5. It sets out, for example, all applications for registrations ever lodged, which is to be recorded, and it contains other particulars of information that the registrar considers appropriate. You will find these particulars of information set out in the sample as shown in the slide. Pages 21, 22. Section 6, Registrar to keep certain documents. The new Section 6 is an improvement on the existing one with the following amendments. In light of the new Land First proposal, memorial or references to memorial will be deleted. They relate to the old system. The registrar may, for the purpose of this ordinance, keep any document lodged under the ordinance, including the standard terms document. The amendment provides better clarity in a sense that this registrar may make a record or keep certified copy of the document. So basically these are drafting improvements without substantial changes to the meaning. The next one is Section 7, page 22. The new section specifies the forms of registers, documents, records to be kept by the registrar. The registrar may also, under or for the purpose of the ordinance, keep, organize, or present in any form and manner documents, records, etc. And to Right, Ms. Doreen Kong, I have a question on Sections 6 and 7. Section 6 provides that the registrar is empowered to destroy the document. Now, of course, in the current system, the registrar definitely will not destroy any document because we have a deeds registration system. The documents must be kept. In the future, under the proposed system, well, I understand that this exists in the old Section 6.3a as well, but here it is said that the registrar can destroy the document. Now, will the registrar exercise this power in the future? I know that the title registration system will be put in place, but I don't feel reassured if the registrar is allowed to destroy any document. Will the power be used casually?
All right, Director. Under what circumstances will you exercise this power? Am I coming through? Thank you. In the existing system, when the law firm provides us with a memorial or document, we will return the documents. When we collect the memorial, we scan it and keep the electronic record. In the future, the same practice will apply. For e-lodgement, we already have an e-copy of a document, so we don't have to destroy any document. For documents sent by a law firm, we will return the document to the law firm. We only keep the application form, that is the memorial form. We scan it and keep the e-copy. For scanned documents, in the future we may have to destroy the physical copy of the document. And we only keep the e-copy. Thank you. Clause 7 amends Section 8, pages 23 to 26. It's about the functions and powers of the registrar. Subsection 2, the registrar may do all such things as are necessary for the better performance of exercise of his powers. Mr. Andrew Lam. Thank you. Section 8, subsection 2. For the registrar to better perform the power, it makes sense. However, when I read other words, it's about the registered interest. For interest not yet registered, or for overriding interests, according to Section 8, can the registrar not ask? Well, the registrar can ask basically anything when there is an application. So there's an overriding power. Is it right? The registrar can ask anything as long as it can help the registrar to better perform his or her power. You do not rule out overriding interest. Is that correct? We need to be very clear. Mr. Lee or registrar? Well, as set out in the provisions for the better performance of exercise of the power of the registrar, then the registrar can ask anything he or she wants. As long as the registrar considers necessary for his better performance of the power, then the registrar can ask anything in addition to registered interest. Well, basically, the registrar can ask anything he wants. Mr. Tong Li-Te. Thank you, Chairman. On page 24, refuse to proceed with the registration of a matter. Brackets 7. Any provision of this ordinance or of any other enactment relating to the application has not been complied with. Do these powers need to be explained in other enactments? For example, when one needs to inspect the windows, but then when one fails to do so, is that a reason for the registrar to reject or to refuse to proceed with the registration of a matter? Well, it depends. It depends on whether there are any non-compliances. Say, if the document sets out that one needs to stamp it, if it hasn't been done, then we will refuse to proceed with the registration of a matter. In relation to the inspection of windows, in other words, when an order isn't complied with, is that a reason to refuse to proceed with the registration of a matter? Well, we will have to read the buildings ordinance before we can give an answer. When one breaks a law, say illegal parking, there is no reason for us not to proceed with the registration of a matter, but that person breaks the law. Just now you mentioned the building department's order. When one fails to comply with the order, one cannot make an application. Is that what you mean? Well, I think this is an extreme example. If there is an ordinance setting out this, of course we will consider. But say for illegal parking, when one doesn't pay the fine, it has nothing to do with the matter in question. Then there is no reason for us to refuse to proceed with the registration of a matter. In other words, we will consider the situation on a case-by-case basis. P.S. I'd like to supplement. Using Mr. Tony Te's example, when the buildings department issues a window inspection order and when the owner fails to comply with the order, I'm not sure if this non-compliance needs to be set out in the register, but I do understand what Mr. Tony Te means. Let's take UBW unauthorized building works as an example. In the case of a UBW, then when the removal order is issued by the buildings department, then it will be shown in the register, but it won't affect the sale of the property. It may affect the price, but there is no impact on the sale of a property. In the case of a UBW, even if there is a removal order, it doesn't mean that the enactment relating to the application has not been complied with. Say what information to furnish, what forms to provide. These are in relation to the enactment relating to the application. It's not about the orders issued by the government department. These are two different matters. Mr. Tony Te? Well, as far as I understand, nature plays a key role in relation to the performance or the power of the registrar. When the registrar considers a matter serious, the registrar has the power to refuse to proceed with the registration of a matter. Just now, PS gave an example in the case of UBWs. Transactions may continue. In 8A, the registrar may designate and amend lot numbers. Can you tell us more about 8A? In the past, at present we don't have this. Can you tell us why you propose to add this one? Page 27, you delete registrar may apply to court for directions. I'd like to hear from the administration. We used to have this section, but now you don't need it. That's why you propose to delete it. Can you tell us more why you propose to delete it? Section 8A. Registrar may designate and amend lot numbers. It is a new section. In general, in conveyancing or in property registration, we have regard to the particulars or information about the owners. In the case of resumption of land by the government, if the government resumes the entire lot, we consider the resumed part as Section A, whereas the yet to be resumed part is RA. In other words, we have this practice, but you are just going to make it clearer. Is that right? This is in practice, right? Yes. Well, hang on. Our meeting is scheduled to end at 6:30. For the sake of completeness, Ms. Doreen Kong, Mr. Louis Long, Mr. Andrew Lam have pressed the button to request to speak. I plan to wrap up the meeting today after these three members speak. Thank you. Section 9. Registrar may apply to court for directions. If any question of law arises in respect of the performance or exercise of any functions or powers imposed or conferred on the registrar by or under this ordinance, the registrar may apply to the court for directions. We have consulted the judiciary, and we shouldn't consult the court for any directions. Instead, we should consult the DOJ for directions. Mr. Tongite, yes, indeed, I find it weird as well. We shouldn't seek directions from the court. All right, it's been deleted now. Mr. Doreen Kong, well, I have three questions about Section 8. It's about the power and the functions of registrar. 7. Just now, Mr. Tongite asked a valid question. The scope could be very wide. E. Any document, information, or explanation mentioned in subparagraph 3 is not provided. Then, the registrar may refuse to proceed with the registration of a matter. In transactions, we need to provide legal opinions for buyers and banks. In the new system, we need to register the interest. Well, as a lawyer, when I find it too wide in scope, it's very difficult for us to say that the likelihood of being able to register is very high. Can you go back and think how to resolve this point? Under other ordinances, it is possible that the application could be refused. Upon the passage of this bill, can the PS tell us the government wouldn't refuse application so easily? The registration is very important. Can you give us peace of mind? I'm a little bit worried.
Another point is about 8C. The person may be required to take an oath or make a declaration. Can you tell us the nature of the oath or affirmation or declaration? let's answer the question on 8E about the registrar's power to refuse to register the matter. I will just say that matters that can be registered today will be able to be registered in the future. That's just the broad understanding, but I cannot guarantee. That's just a general scenario. Mr. Chair or Deputy Chair just now asked some questions. You may not be able to answer them fully today. You can give us a detailed written reply after the meeting. We're concerned about the powers that a registrar enjoys and whether the powers will affect the effect of any transaction. So let's save that for the written answer. Just answer part 2 of Ms. Doreen Kong's question first about the oath. There may be some unclear matters relating to the registration, and that we would demand the applicant to give a clear answer, and this can only be done by way of an oath. What exactly are you referring to? What matters will be deemed unclear? Right, go back and give it a thought. I'll just let Mr. Louis Long ask his question first. Chairman, I'm concerned about the powers of the registrar, especially for the amended Section 8, the Roman numeral 7. I'm reading from the English version.
咁即係雖然李生剛才就講話係即係依家。
So you just answered basically matters that can be registered under the current LRO can be registered under the future LTO. But that's just your understanding. If you take the literal meaning of this provision, the registrar is given a lot of power, especially when there is reference to any other enactment. So perhaps you should go back and clarify this matter, at least tell us that the registrar's power is not limitless, just to reassure the public and the sector. I agree. I think you should go back and mull it over and make sure that the boundaries are clearly set. I'll just give the floor to Mr. Andrew Lam now. I heard your answer to Mr. Tony Jeff's question. I know that the registrar is empowered to amend the lot number under the current system. But I want to emphasize that this bill relates to new land. So taking this perspective, there may be a question mark about why there would be a need to make any amendment. I'm not saying that this power should be scrapped, but you need to address the concerns. Under the current system, if you amend the lot number, you may need to inform the original owners or other stakeholders, and I frankly say that at the moment this system is opaque. You may not be able to give me an answer now, but do give me the details in your written reply as to how you will inform the public about the amendments of lot numbers. Right, would you rather give a question now, give an answer now, or a written reply? A written reply later. All right. Let's just pause here. Next time you will take it from here about the powers of the registrar. I think we need to give the administration some time to consider the written replies to clarify matters. So I will continue next time. I will wait for your written response. Meanwhile, AOB. Nothing under AOB. The next meeting is scheduled for the 9th of June, but I'll work out another schedule with the administration. We'll see whether the next meeting is a 2-hour or 4-hour meeting. For the time being, let's tentatively set the next meeting date to be the 9th of June, and we'll work out the schedule and the venue with the Secretariat. Right, so next meeting, the morning of the 9th of June. If there's nothing under AOB, the meeting's adjourned. Thank you.